Thank you. So now we begin the program as set out. We had a wonderful framing of today's Chamber 2 on geopolitics, the geopolitics of the genocide in Gaza and the rest of Palestine, from Richard Falk and Craig McIver. We are now moving to the first panel, panel 1, which is exploring political realism and contemporary geopolitics. Our two speakers are Richard Falk, who has already been well introduced, and Paulina Chan. Paulina is currently working on international disarmament advocacy, and she's a contributor, as you know, to Chamber 2 of the Gaza Tribunal. So I'm going to first of all hand over to Richard, who is beginning this panel, and then he'll hand over to Paulina. Thank you very much.
Thank you, Penny, and I'm glad we've solved the technical problems. And I should say that the two papers that will be discussed in this segment were co-authored by myself and Paulina Chan, and we're dividing them in a way that both of us will speak to parts of the first paper, and Paulina will introduce the second one, and I'll speak at the end of that presentation. So let me begin and, in a sense, continue the kind of descriptive explanations that Craig and I tried to depict in the introductory remarks. And first, I will try to speak of the basic elements of political realism and how that bears on the inability to stop genocide in Gaza. Ever since the Peace of Westphalia in 1648, the system of world order that has prevailed has been West-dominated and state-centric, with a few great powers shaping patterns of behavior by recourse to balance of power logic, or according to their political ambitions and capabilities. Within such a framework, world order has evolved in response to historical circumstances, while retaining its hybrid identity of statism and geopolitics. Existing patterns of regulation are shaped by the formal equality of states as modified in practice by the primacy of geopolitics, which presupposes inequality and a hierarchy among states. Derive this from this orientation, even earlier patterns of international behavior that revolved around historically grounded belief that might makes right in relations between organized political communities. The often quoted adage of Thucydides in his history of the Peloponnesian Wars remains a touchstone of contemporary political realism. And I quote, "The strong do what they will, while the weak do what they must." This was a favorite saying that Henry Kissinger often quoted, and it typifies also the kind of realism pursued by Zbigniew Brzezinski. In other words, the prominent political realists of the West. This realist ethos was somewhat drawn into question by the world wars of the 20th century, with the Nazi genocide, the horrors of colonization around the world, and now more dramatically by Israel's post-October 7 atrocities in Gaza. After World War II, the victorious states, building on these destructive milestones, proclaimed an intention to construct a new world order, in effect, a post-Westphalian framing of international relations that claimed to supplant or at least marginalize the role of hard power in the relations between sovereign states, and to respect the rule of law as guiding behavior of the strong as well as the weak. It also purported to promote democratic procedures, the ideals of a human rights political culture, and a common path to economic and political development. The essential nature of this vision of global reform was set forth in the UN Charter, especially in its preamble, with certain commitments to save succeeding generations from the scourge of war, to reaffirm faith in fundamental human rights, to accept an unconditional prohibition on aggressive or non-defensive uses of force, respect for international law, and to enact the furtherance of social and economic development for all nations. However, even as this vision was set forth, so was its negation, and that is a central problem of post-1945 world order. Despite a seeming rhetoric of commitment, the operational provisions of the UN Charter and the framing of the economic order in the Bretton Woods institutions of the World Bank and IMF exhibited a pervasive, although unacknowledged, ambivalence toward the ostensible abandonment of the pre-1945 hard power idea of world order. Above all, the UN Security Council, the only organ with the power of decision and enforcement authority, was deliberately crippled and de-democratized by conferring a right of veto and permanent membership in the West-dominated group of winners of World War II. This meant that the strongest and potentially most dangerous states were given unrestricted legal discretion to pursue their strategic interests rather than to adhere to international law and the provisions of the UN Charter, including the governance of the use of force. There were additional features of the Charter that justified an assessment that the UN was designed to be weak regarding global security and war prevention. For instance, undermining the authority of decisions of the UN Judicial Tribunal, the International Court of Justice, principally by making enforcement totally dependent on Security Council unified action. The ICJ was therefore limited by the need to circumvent the exercise of the veto, and the label of advisory opinions was used to dilute the effective authority of judicial outcomes unless a rare political consensus happened to exist among the permanent 5 members of the Security Council. Over the years, the result has been the marginalization of the UN and of international law, and particularly in the context of major conflicts and atrocities, particularly if they were attributed to the P5 countries or their allies and countries that were their friends. As such, the architects of the post-1945 world order created conditions whereby the influence of Westphalian approaches to foreign policy continue to be expressed by most governments. This has produced a gaping enforcement gap between the rule of law and geopolitical primacy. This gap has recently been dramatized by the failures of the UN or the P5 to take any serious action to stop Israel's prolonged, transparent genocide in Gaza, which it has carried out against the Palestinian people for the past 19 months. A second failure of the operational realities of current world order is vividly exhibited by the complicity of governments in enabling Israel to continue the Gaza genocide in the face of a tidal wave of worldwide popular opposition and the defiance by Israel of clearly applicable fundamental provisions of international law. This complicity is asserted rather than hidden and has taken various forms, including the provision of weapons, financial contributions, diplomatic support, the use of official platforms to disseminate Israeli propaganda, and intelligence gathering. There exists an international reluctance to challenge formally such enabling behavior, especially to mount allegations against the United States, the most prominent and unabashedly complicit government and the leading P5 supporter of Israel. This is highlighted by the US even being allowed, without visible signs of dissent, to exert a major surrounding mediating influence on day-after arrangements pertaining to occupied Palestine. In other words, despite its complicity, the US has not been disqualified from acting as a custodian of responsible negotiations for the future of the Palestinian people, more aptly should have been made responsible for reparations as at least a minimum form of accountability. As matters now stand with reference to the destruction of Gaza, a serious complicity gap exists between affixing legal responsibility for complicity and its treatment in practice. A third and final failure of this present world order is the prioritization of the primacy of geopolitics over the rule of law, which helps explain why enforcement and complicity deficiencies are tolerated in the post-1945 world. Its focus on the accountability of individuals, corporations, and states is an integral, although flawed, systemic violation of the peace process that followed World War II. The winners in the war collaborated also in creating the Nuremberg trials and the Tokyo war crimes tribunals to assess the allegations against leading surviving military, political, and even corporate officials of the losing side in the war. These war crimes trials after World War II, similar to the process that I have described in relation to the United Nations, meant that the application of judicial criminal justice was flawed by a startling injustice, namely, only the crimes of the losers in the war were made subject to prosecution and punishment, leaving the crimes of the winners, including the dropping of atomic bombs, beyond institutional or legal scrutiny. Accordingly, the winners, by their own initiative, established the tribunal that judged the losers, including its format and the selection of presiding judges. For the defeated nations, victimized by strategic bombing of their major cities, culminating in the atomic bombs on Hiroshima and Nagasaki, this produced a widespread cynicism, especially in Japan and Asia, about the relevance of international criminal law within a post-Westphalian legal order that claimed to embody principles of justice and equality in the application of law. No principle is more fundamental to the rule of law than the precept, equals shall be treated equally, which was fundamentally violated at Nuremberg and Tokyo by this treatment of the crimes of the winners as exempt from accountability and by exerting exclusive control over the judicial framework to adjudge guilt and innocence. Let me now turn this presentation over to Paulina Chan, my co-author, who will talk about civil society activism and its role in establishing the Gaza Tribunal as an example of a people's tribunal. Paulina, the floor is yours.
Due to a world order underpinned by political realism, which Richard has so eloquently elaborated on, our paper goes on to argue how civil society has become not just relevant, but indispensable. When governments turn away, when courts are neutered, and when media channels are manipulated, it is up to the people, acting collectively and courageously, to raise the alarm, gather evidence, educate the public, and demand justice. Civil society activism in the international arena is not new, but its importance is growing. As mentioned yesterday, the Russell Tribunal on the Vietnam War demonstrated how non-state actors could hold powerful nations morally accountable for their actions, even in the absence of formal legal enforcement. Though dismissed at the time by mainstream institutions and the media, the Russell Tribunal left a lasting legacy by establishing a model for civic intervention into global affairs. This tradition has since evolved into a broader movement of people's tribunals, grassroots campaigns, and transnational networks of solidarity, each seeking to spotlight and redress violations of human dignity where governments and courts have failed. These initiatives have addressed issues as varied as colonial violence, nuclear weapons, corporate exploitation, environmental degradation, and military aggression. What all these movements share is a belief that justice is not the exclusive domain of states or courts. It is a moral obligation and civic responsibility. Civil society activism empowers ordinary individuals to become custodians of truth and agents of change. It offers a democratic corrective to institutions that are too often captured by elite interests or rendered inert by political gridlock. In a world dominated by geopolitical interests and the failure of state institutions to uphold justice and human rights, civil society activism has emerged as one of the last remaining frontiers for ethical accountability, resistance, and truth-telling. The most powerful function of civil society activism is its ability to redefine what is politically possible. Throughout history, movements that began as marginal or ridiculed by establishment have ultimately changed the course of nations and reshaped the global order, from the anti-apartheid movement in South Africa to the climate justice movements of today. Such movements have challenged impunity when courts and states remained silent, and they have kept hope alive for those most directly affected by injustice, reminding them and the world that they are not alone. The Gaza Tribunal stands in direct continuity with this tradition of principled civil society action. It is a tribunal of conscience, a moral forum organized by and for the people, created in response to the catastrophic failure of international institutions to stop, investigate, or even in some cases, acknowledge the genocide taking place in Gaza. The Gaza Tribunal aims to document evidence of Israeli war crimes and genocidal conduct, to expose the complicity of other actors, including states, corporations, and media institutions, to educate the public and galvanize global civic action, and ultimately to pressure governments and institutions into adopting just and humanitarian policies. The Gaza Tribunal is not a court in the conventional sense. It does not claim legal jurisdiction or the power to issue binding rulings, but what it does possess is the legitimacy of moral clarity, the force of public conscience, and the ability to amplify marginalized voices. By placing witness and experts at the center of its proceedings, the Gaza Tribunal not only validates the suffering of the Palestinians, but also builds a permanent historical record, one that could serve as a foundational tool for future justice efforts. In the case of Gaza, where the mainstream media has often echoed state propaganda and obscured the scale of human suffering, civil society has played a crucial role in disseminating uncensored testimonies, videos, and reports. It has also supported protests, organized aid efforts, and launched campaigns for boycotts, divestment, and sanctions. Tribunals like the Gaza Tribunal represent the formalization of this activism, giving it structure, continuity, and a platform for sustained engagement. While they cannot enforce their judgments, they exert indirect influence by shaping public opinion, inspiring movements, and pressuring policymakers. Civil society activism is no longer just a supplement for formal justice. It is perhaps one of the only functioning mechanisms we have left to uphold ethical standards, document crimes, and confront global injustice. The Gaza Tribunal embodies this potential, standing as both an indictment of international complicity and a beacon for how ordinary people can confront extraordinary wrongdoing. Thank you. That's the end for our first presentation. And so I suppose I'll just go on to the next one. Okay. So the first report, as we know, critiqued the ideology of political realism and its influence on international responses to mass atrocities. Our second report, called Past Global Responses to Genocide, A Record of Failure, aims to provide concrete examples of this phenomenon. So this report seeks to demonstrate to the jury of conscience that the world's failure to stop the Palestinian genocide reflects a broader recurring failure of the international community to act, despite the Genocide Convention and decades of never again rhetoric after the Holocaust. By examining the genocide cases of Cambodia, Rwanda, Sudan, Myanmar, and Palestine, the report traces a historical pattern in which geopolitics, strategic interests, and racialized perceptions of whose lives matter most continue to shape international responses to mass atrocities. In the case of Cambodia, between 1975 and 1979, under the Khmer Rouge regime, Cambodians underwent a genocide in which approximately 1.5 to 1.7 million people were experiencing systematic execution, displacement, torture, starvation, and forced labor. Despite these crimes, Cold War politics led the US and its allies to support the regime as a counterbalance to their then geopolitical rival, Communist Vietnam. Moreover, the UN continued to recognize the Khmer Rouge as Cambodia's legitimate government until 1991, despite its demonstrated record of genocidal conduct, as well as having been ousted in 1979 by a Vietnamese incursion. In response to the international community's inaction, the 1979 People's Revolutionary Tribunal was initiated, but its verdicts on Khmer Rouge leaders were not internationally recognized. Then, decades later, in 2005, the internationally supported Khmer Rouge Tribunal was established, and though it delivered delayed justice by indicting some key Khmer Rouge officials, the tribunal was stalled by political and institutional hurdles, leaving many officials untried before their deaths. In the Rwandan genocide of 1994, over the course of about 100 days, roughly 800,000 people lost their lives. Despite being aware of the imminent and ongoing genocide through early warnings from UN peacekeepers, NGOs, and diplomats, the UN Security Council and the larger international community failed to act decisively. A crucial warning, now known as the Genocide Facts, was sent to the UN Secretariat 3 months before the genocide began. Yet no preventive measures were taken, and requests for increased UN forces in Rwanda were ignored. Instead, UN peacekeepers in Rwanda were constrained by a limited mandate, which was then suspended following the onset of violence. Meanwhile, in the heat of the violence, Western states sent elite troops to bordering nations to evacuate their own citizens from Rwanda, excluding Rwandans from such efforts. Lastly, and notably, key players like the United States putatively contributed to the Security Council's ambivalence by deliberately avoiding to label the crisis as a genocide so as not to induce legal obligations. The Darfur genocide in Sudan between 2003 and 2008 saw the displacement of millions and the killing of at least 300,000 people through state-sponsored militia attacks. Despite early NGO warnings and escalating violence beginning in 2003, the UN Security Council failed to take effective action. While initial UN resolutions in mid-2004 called for peace and imposed an arms embargo, they lacked enforcement mechanisms and were quickly undermined. Though the US declared the crisis a genocide by late 2004, a UN Commission of Inquiry declared this was not the case, further complicating the international response. Rather than the Darfur genocide, the UN was focused on resolving Sudan's North-South civil war through a 2004 comprehensive peace agreement, which ironically excluded Darfur and sadly emboldened violence. Lastly, efforts to strengthen the intervention were obstructed by UN Security Council's members' strategic, economic, and military interests in Sudan. And although the ICC eventually indicted President Omar al-Bashir in 2009 and 2010 for crimes against humanity, war crimes, and genocide in Darfur, hundreds of thousands of lives had already been taken. In Myanmar, the Rohingya people have been subject to a state-sponsored systematic genocide involving forced displacement, mass killing, and sexual violence. Though the crisis originated in 1978, It escalated in 2016 and 2017 after a Rohingya militant attack prompted state-led brutal clearance operations. While the UN condemned these abuses and held briefings on the topic in 2017, the UN Security Council did not take substantive follow-up steps. Early international measures, such as the US and EU military sanctions and arms embargoes, were uncoordinated and lacked binding authority. Some governments hesitated to act forcefully due to geopolitical interests. Viewing Myanmar as a fledgling democratic ally, many favored quiet diplomacy, which avoided mentioning the Rohingya crisis rather than confrontation. This reluctance to hold the government accountable, along with the acceptance of narratives portraying Rohingya peoples as terrorists, enabled further violence. A turning point came in 2019 when the Gambia brought a case against Myanmar to the ICJ, invoking the Genocide Convention. The ICJ ordered provisional measures to prevent further atrocities, but such rulings lack immediate enforcement power, making them unable to respond swiftly to an ongoing genocide. Finally, regarding the situation in Gaza, our report critiques Israel's military operations in the region and the broader Palestinian territories following October 7, 2023. It situates them in a history of settler colonialism, the Nakba, and the ongoing denial of Palestinians' self-determination. International responses to Gaza echo past failures, as powerful states stand idly by or even offer Israel political cover for its atrocities. The international community's inaction and complicity is shaped by deep-rooted geopolitical factors, such as Israel's historical alignment with Western interests, its portrayal as a democratic outpost in a volatile region, and the powerful influence of pro-Israel lobbying in the West. These forces have enabled Israel to expand territorial control while avoiding meaningful accountability. Despite widespread awareness of the genocide thanks to digital technologies enabling real-time documentation of events, and despite the death of over 53,000 Palestinians and an imminent famine across the Gaza Strip, most global leaders have only gone so far as to adopt symbolically critical stances rather than take concrete actions. This is a glaring reminder that states continue to prioritize their strategic interests over humanitarian law and moral obligations. In conclusion, the report asserts that the failure to prevent genocide from Cambodia to Gaza are not isolated mistakes, but symptoms of a deeply flawed international system. Legal instruments like the Genocide Convention are repeatedly undermined by political and economic calculations. Racial and civilizational hierarchies further influence who receives international sympathy and intervention. Even when legal bodies like the ICC or ICJ act, they do so slowly, and their actions often do not carry the enforcement necessary to halt ongoing atrocities. The report identifies a recurring pattern of selective moral engagement. When victims are geopolitically inconvenient or racially marginalized, action is delayed or denied. Real prevention and accountability require more than legal frameworks. They demand a radical shift in global political will, an ethos of common humanity, and instruments that are insulated from geopolitical manipulation. Thank you, and I'll pass it over to Richard now.
I want to follow up on what Paulina has laid before you and to offer a couple of reinforcing generalizations. The first of which is that our report tries to emphasize, on the one side, the distinctiveness of each genocide that partakes of a particular set of circumstances. But despite this distinctiveness, international history from colonial times, from pre-modern times, exhibits this inability and unwillingness to effectively protect victims of genocidal violence. And in that sense, the spectacle of atrocity that we've been witnessing in Gaza is part of a recurring pattern that even applied to the Holocaust, where nothing materially significant was done to halt a genocidal project of the Nazi regime until it waged a war of aggression that challenged the strategic interests of the Western powers. And it's it's extremely important to recognize this resistance to waging peace, so to speak, on behalf of human rights, no matter how fundamental, no matter how much they shock the conscience of humanity. And in the digital age, this shock is portrayed to the eyes and ears of the world on a daily basis that creates a certain kind of populist moral fervor that exhibits traits of solidarity with the victims of genocide. And in this sense, the Palestinian struggle for self-determination has been characterized by exceptional resilience and resistance under very unfavorable conditions, and does represent a challenge to the whole of humanity. It is really become the moral crisis of the 21st century. And our tribunal, the Gaza Tribunal, it makes an effort to acknowledge this deficiency in the global order and to work toward the empowerment of people to overcome the failings and shortcomings of the structure of world order. And we place great hope in this possibility of mobilizing solidarity initiatives of a nonviolent character that can shape the outcome of a conflict more than the balance of military forces. This was demonstrated in the Vietnam War, where the United States had total control over the air, sea, and land dimensions of the war, and yet lost the war. It was also demonstrated in South Africa by the degree to which an unexpected and surprising transformation of the white supremacist leadership didn't involve a moral awakening, but it involved posing a choice between an apartheid racist isolation in the world and a normalization based on the renunciation of institutional racism. We hope that we will become part of that process that not only contributes to Palestinian national liberation and attainment of self-determination, but also is a pedagogical experience for humanity in the need to give law and justice a much more central place in the preservation of security and the well-being of humanity. Let me stop there and thank you very much.